Quiet title. Some 70 plus million mortgages and deeds of trust could have fatally flawed titles due to MERS recoordination. This, coupled by missing paperwork and the securitization process, could actually compound the slanders on title. The term slander of titles is normally a claim involving real estate in which one entity falsely claims to own another entity's property. Most every state has a statute that gives property owners the right to file an action to quiet title. Every property owner who bought or refinanced between 2001 and 2008 should really take a close look as to whom they are paying their mortgage, and to also determine whether that bank or mortgage company even has the right to collect, much less the right to foreclose. Case in point, in a Massachusetts case, Bevacqua versus Rodriguez, Mr. Bevacqua went to court to quiet title only to find out the U.S. bank didn't really even own the property it sold him. Beware investors and prospective buyers of short sales and real estate owned properties. Before you purchase, be sure you thoroughly check out the chain of title to the property. As the name implies, a chain of title follows the registration of a deed to property from beginning owner to present owner. The land title records are officially maintained at each land titles registry. Taken from Wikipedia, in the United States, some holders of mortgage debt may be unable to establish chain of title, despite the fact that clear chain of title can be required by the mortgage holder before foreclosure can proceed. Widespread lack of clarity in chain of title results from a 1995 decision by many lenders to rely on a third entity, often a specific company, MERS, to hold title nominally in an effort to enable the buying and selling of mortgage liabilities without registration of changes of ownership with local governments. Many U.S. states have objected and even sued over this practice. If MERS has not kept up records of transfers of mortgages or note holders with the land title registry, they may have contributed to a break in the chain of title. In the Supreme Court ruling of Carpenter v. Longon in 1872, the judge has stated clearly, the note and mortgage are inseparable, the former as an essential, the latter as an incident. An assignment of the note carries the mortgage with it, while an assignment of the latter alone is a nullity. Meaning if the note and mortgage are split, the mortgage becomes a nullity, or is worthless. Too many questions arise when the note and the mortgage security are split. For example, who now are the note holders? How many times has the note been split? Have some parties received insurance proceeds on notes that are in default? Are there even any real damages? In layman terms, the land registration system is messed up. Some banks attempting to foreclose on property do not even own the mortgage notes, let alone the mortgage security. HBN's role is to educate, guide, and help to provide evidence to property owners so they may clear their titles or defend their property from pretend lenders or corporate entities that otherwise have no legal interest in property they are attempting to charge fees, payments, and even foreclose on. Give us a call. We'll provide you with meaningful information, and if you wish, provide you with the valuable service that other property owners were so grateful to receive from HBN. HBN, just as a reminder, is not a legal firm, nor does it provide legal advice. Anyone seeking legal advice should, of course, consult with an attorney. Furthermore, HBN does not provide loan modification services. What we do at HBN is provide evidence to permit property owners like yourself to go on the offensive to defend property from false representation of note holders.